Hello friends, today I am going to discuss about the topic winding up under the Companies Act 2013. In this lecture, I will be dealing with the procedural aspects of winding up of a company. Firstly, let's briefly discuss what winding up means. Winding up is a method of putting an end to the life of a company. In his book, The Principles of Modern Company Law, Professor Gower states, winding up of a company is the process whereby its life is ended and its property administered for the benefit of its creditors and members. An administrator called a liquidator is appointed and he takes control of the company, collects its assets, pays its debts and finally distributes any surplus among the members in accordance with their rights. Winding up is conducted in accordance with uniform rules, and the Companies Act 2013 contains a number of provisions applicable to every mode of winding up. The provisions are contained in Chapter 20, Part 3, Sections 324 to 358. Before embarking upon those rules, let's first understand the concept of contributories. Section 2, Subsection 6 of the Act states that a contributory means a person liable to contribute to the assets of a company in the event of winding up and includes the holders of any shares which are fully paid up. Once the winding up of a company takes place, if any property of the company is in the custody of some person, the liquidator can, through an application to the Company Law Tribunal, recover possession of that property. To realize the uncalled residue of the company's capital, the liquidator has to call upon the shareholders, who are then called contributories, to pay the unpaid balance. The liability of a member of a company to be included in the list of contributories is not ex contractu, that is, it does not arise by virtue of his contract to take shares. His liability is ex lege, which means that it arises by reason of the fact that his name appears on the register of members of the company. It is, therefore, no answer for the contributory against the claims of the company to say that although his name appears on the register, he is not liable because the allotment to him was void. Talking about settlement of the list of contributories, liability of past members and application of assets. Section 285 of the Act provides that as soon as possible after the passing of a winding up order by the tribunal shall settle a list of contributories, cause rectification of register of members in all cases where rectification is required in pursuance of this Act, and shall cause the assets of the company to be applied for the discharge of its liability, provided that where it appears to the tribunal that it would not be necessary to make calls on or to adjust the rights of contributories, the tribunal may dispense with the settlement of a list of contributories. In settling the list of contributories, the tribunal shall distinguish between those who are contributories in their own right and those who are contributories as being representatives of or liable for the debts of others. Every person has to be included who is or has been a past member and who is liable to contribute to assets for requisite payments and for rights of contributories as between themselves. Talking about the liability of past members. Such liability is subject to, firstly, a person who has been a member shall not be liable to contribute if he has ceased to be a member for the preceding 1 year or more before the commencement of the winding up. Secondly, a past member shall not be liable to contribute in respect of any debt or liability of the company contracted after he ceased to be a member. Thirdly, no past member shall be liable to contribute unless it appears to the tribunal that the present members are unable to satisfy the contributions. Fourthly, in the case of a company limited by shares, no contribution shall be required from any person who is or has been a member exceeding the amount, if any, unpaid on the shares in respect of which he is liable as such a member. Fifthly, in case of a company limited by guarantee, No contribution shall be required from any person who is or has been a member exceeding the amount undertaken to be contributed by him to the assets of the company in the event of its being wound up. But if the company has a share capital, such member shall be liable to contribute to the extent of any sum unpaid on any shares held by him, as if the company were a company limited by the shares. In the case of Paras Ram Brij Kishore versus Jagrao Trading Syndicate Limited, the liquidator of a company called upon the defendant to pay the uncalled amount of his shares. His shares had been forfeited before the winding up and therefore he was a past member. But the existing members had not called upon to contribute to the full extent of the unpaid amount of their share money. The court in this case held that in the circumstances, a past member could not be held liable to contribute till liability of present members was exhausted. Talking about the rules in accordance to which the winding up of a company takes place. These constitute the provisions applicable to every mode of winding up specified under Part 3 of Chapter 20 of the Companies Act 2013. The first important concept is payment of liabilities. An important duty of the liquidator is to pay off the company's liabilities. All persons who are entitled to receive money from the company have the right to claim their respective amount from the liquidator. Section 324 deals with debts of all descriptions to be admitted to proof. It states that in every winding up, all debts payable on a contingency and all claims against the company, present or future, certain or contingent, ascertained or sounding only in damages shall be admissible to proof against the company, a just estimate being made so far as possible of the value of such debts or claims as may be subject to any contingency or may sound only in damages or for some other reason may not bear a certain value. A just estimate shall have to be made so far as possible of the value of such debts or claims as are subject to any contingency or may sound only in damages or for some other reason may not bear a certain value. Where the company in liquidation is insolvent, insolvency rules will apply and only such claims shall be provable against the company as are provable against an insolvent person. According to the present law of insolvency, demands in the nature of unliquidated damages arising other than by reason of a contract or breach of trust and debts and liabilities which are incapable of being fairly estimated, a claim for damages for misrepresentation in purchase of shares are not provable in insolvency. As per Section 325 of the Act, such rules are to apply to, firstly, debts provable, secondly, the valuation of annuities and future and contingent liabilities, and thirdly, the respective rights of secured and unsecured creditors, provided that the security of every secured creditor shall be deemed to be subject to a pari passu charge in favour of the workman to the extent of workman's portion therein, and where a secured creditor, instead of relinquishing his security and proving his debts, opts to realize his security, the liquidator shall be entitled to represent the workman and enforce such a charge. Any amount realized by the liquidator by way of enforcement of such charge shall be applied rateably for the discharge of workman's dues, and so much of the debts due to such secured creditor as could not be realized by him, or the amount of workman's portion in his security whichever is less, shall rank pari passu with the workman's dues for the purpose of Section 326. Section 326 deals with the overriding preferential payments. It states that, notwithstanding anything contained in this Act or any other law for the time being in force in the winding up of a company, workmen's dues and debts due to the secured creditors to the extent such debts rank under Clause 3rd of the provision of subsection 1 of Section 325, pari passu with such dues shall be paid in priority to all other debts. Another concept is that of preferential payments. The first payment to be made are called preferential payments. They have to be paid in priority to all other debts. Section 327 of the Act provides that such payments are, firstly, all revenues, taxes, cesses and rates due from the company to the central government or a state government or to a local authority at the relevant date, and having become due and payable within 12 months immediately before this date. Secondly, all wages or salary including wages payable for time or piecework and salary earned wholly or in part by way of commission of any employee in respect of services rendered to the company and due for a period not exceeding 4 months within the 12 months immediately before the relevant date, subject to the condition that the amount payable under this clause to any workman shall not exceed such amount as may be notified. Thirdly, all accrued holiday remuneration becoming payable to any employee or in case of his death to any other person claiming under him on the termination of his employment before or by the winding up order or as the case may be, the dissolution of the company. Fourthly, all amounts due in respect of contributions payable during the 12 months before the winding up under the Employees State Insurance Act 1984 or any other law. Fifthly, all amounts due in respect of any compensation or liability for compensation under the Workmen's Compensation Act 1923 in respect of death or disablement of any employee of the company. Sixthly, all sums due to any employee from the Provident Fund, the Pension Fund, the Gratuity Fund or any other fund for the welfare of the employees maintained by the company. And lastly, the expenses of any investigation held in pursuance of Section 213 and Section 216 insofar as they are payable by the company. After retaining sums necessary for meeting the costs and expenses of winding up, the stated debts have to be discharged forthwith so far as assets are sufficient to meet them. Then there is Section 329 of the Act, which deals with transfers not in good faith to be void. Any transfer of property, movable or immovable, or any delivery of goods made by the company, not being a transfer or delivery made in the ordinary course of its business or in favour of a purchaser or encumbrance in good faith and for value consideration if made within a period of 1 year before the presentation of a petition for winding up by the tribunal or the passing of a resolution for voluntary winding up of the company shall be void against the company liquidator. But there are transactions which are protected from the operation of this rule. A transfer or delivery of property made in the ordinary course of the business of a company and a transfer or delivery of property in favour of a purchaser in good faith and for value consideration. Then there is Section 333 of the Act, which deals with disclaimer of onerous property. A liquidator may abandon onerous properties belonging to the company. The kinds of properties which are regarded onerous for the purposes of Section 333 are land of any tenure burdened with onerous covenants, shares or stocks in companies, any other property which is unsaleable or is not readily saleable by reason of the fact that it requires the possessor of the property to perform certain onerous acts or pay a sum of money, unprofitable contracts. The company liquidator may, with the leave of the tribunal, claim any such property. It is the duty of the tribunal to help the company liquidator to get rid of onerous and burdensome contracts whenever it's necessary. The company liquidator may, with the leave of the tribunal, disclaim any such property. It is the duty of the tribunal to help the company liquidator to get rid of onerous and burdensome contracts whenever it's necessary to safeguard in full the interests of the body of creditors and the shareholders of the company. The disclaimer should be in writing, signed by the liquidator. It has to be made within 12 months after the commencement of winding up and such extended period as the tribunal may allow. Where, however, the liquidator does not come to know of the existence of an onerous property within 1 month of the commencement of the winding up, the period of 12 months shall begin to run from the date of his knowledge. The disclaimer determines in respect of the property disclaimed the rights, interests and liabilities of the company. It releases the company and the property from liability, but it does not affect the rights or liabilities of any other person in respect of that property. The tribunal may, before granting the disclaimer, require notices to be given to persons interested in the property. Sometimes a person interested in any such property may have required the liquidator to decide whether he will or will not disclaim the property. In such a case, the liquidator should, within 28 days of such extended period as may be allowed by the tribunal, give notice to the applicant that he intends to apply to the tribunal for leave to disclaim. If he does not do so, he shall not be entitled to disclaim the property, and where the property is a contract which he has not disclaimed within the required time, he shall be deemed to have adopted it. The term contract in this section has been held not to include lease. The outstanding contracts do not ipso facto become inoperative on the commencement of winding up. They remain binding unless disclaimed or rescinded as allowed by the section. The contract may be rescinded on such terms as to payment by or to either party of damage for non-performance or otherwise as the tribunal considers just and proper. Any damage so becoming payable to any person may be proved by him as a debt in winding up. The next provision, that is section 334, deals with transfers etc. after commencement of winding up to be void. In the case of a winding up by the tribunal, any disposition of the property, including actionable claims of the company and any transfer of shares in the company or alteration in the status of its members made after the commencement of the winding up shall, unless the tribunal otherwise orders, be void. Then we have section 335, which pertains to certain attachments, executions, etc. in the winding up by tribunal to be void. Where any company is being wound up by the tribunal, any attachment, distress or execution put in force without leave of the tribunal against the estates or effects of the company after the commencement of the winding up, or any sale held without the leave of the tribunal of any of the properties or effects of the company after such commencement shall be void. Another concept is that of falsification of books, which is dealt by section 336. It provides that if any officer or contributory of a company has, with the intent to defraud or deceive any person, destroyed, mutilated, altered, falsified or secreted any books, papers or securities of the company, he is punishable with imprisonment and fine. A person who is privy to such acts is also punishable. There is similar penalty for making any false or fraudulent entry in any book or register or document of the company. This type of offence has been included under section 336, subsection 1, clause D. Section 337 of the Act deals with penalty for frauds by officers. If any person being at the time of commission of the alleged offence an officer of a company which is subsequently ordered to be wound up by the tribunal or which subsequently passes a resolution for voluntary winding up, has, by false pretenses or by means of any fraud, induced any person to give credit to the company with intent to defraud the creditors of the company, or any other person has made or caused to be made any gift or transfer of or charge on, or has caused or connived at the levying of any execution against the property of the company, or with intent to defraud the creditors of the company has concealed or removed any part of the property of the company since the date of any unsatisfied judgment or order for payment of money obtained against the company or within 2 months before that date. He shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years, and with fine, which shall not be less than 1 lakh rupees, but which may extend to 3 lakh rupees. Talking about liability where proper accounts are not kept. Section 338 deals with it. It states that where a company is being wound up, if it is shown that proper books of account were not kept by the company throughout the period of 2 years immediately preceding the commencement of the winding up, or the period between the incorporation of the company and the commencement of the winding up, whichever is shorter, every officer of the company who in default shall, unless he shows that he acted honestly and that in the circumstances in which the business of the company was carried on, the default was excusable, but punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years, and with fine which shall not be less than 1 lakh rupees, but which may extend to 3 lakh rupees. Subsection 2 provides that proper books of accounts are deemed to be not kept if such books of accounts as are necessary to exhibit and explain the transactions and financial position of the business of the company, including books containing entries made from the day to day in sufficient detail of all cash received and all cash paid, have not been kept, and where the business of the company has involved dealing in goods, statement of the annual stock takings, and except in the case of goods sold by way of ordinary retail trade, of all goods sold and purchased, showing the goods and the buyer and the sellers thereof in sufficient detail to enable those goods and those buyers and sellers to be identified, have not been kept. Another concept is that of company liquidation dividend and undistributed assets account. Section 352 of the Act provides, where any company is being wound up and the liquidator has in his hands or under his control any money representing, firstly, dividends payable to any creditor but which has remained unpaid for 6 months after the date on which they were declared, or secondly, assets refundable to any contributory which have remained undistributed for 6 months after the date on which they become refundable. The liquidator shall forthwith deposit the said money into the separate special account to be known as the Company Liquidation Dividend and Undistributed Assets account maintained in a scheduled bank. The liquidator shall, on the dissolution of the company, pay into the Company Liquidation Dividend and Undistributed Assets account any money representing unpaid dividends or undistributed assets. Any money representing unpaid dividends or undistributed assets in his hands at the date of dissolution. He has to furnish to the registrar a statement in the prescribed form setting forth in respect of all sums included in such payment, the nature of the sums, the names and last known addresses of the persons entitled to participate therein, the amount to which each is entitled and the nature of his claim thereto, and such other particulars as may be prescribed. The bank has to give him a deposit receipt, which is an effectual discharge of the company liquidator of his responsibility. Where a company is being wound up voluntarily, the company liquidator shall, under subsection 1 of section 348, deposit such amounts within 14 days of the date of filing the statement with the registrar in the Company Liquidation Dividend and Undistributed Assets account. A claim to any portion of such money can be filed with the registrar, who may pay the amount if satisfied with the claim as to entitlement of such claimant. The registrar has to settle the claim within 60 days. If he is not doing so, he must give reasons for it. If the money remains in the account unclaimed for a period of 15 years, it has to be transferred to the general revenue account of the central government. Any claim for such money would then be termed as an order for refund of revenue. If the liquidator does not deposit the money into the account, he has to pay 12% per annum interest on the amount so retained, and also pay such penalty as may be determined by the registrar. The central government may, in any proper case, remit the interest either in whole or in part. the liquidator would also be liable to pay any expenses occasioned by reason of his default. Where the winding up is by the tribunal, the liquidator would also be liable to have all or such part of his remuneration as the tribunal may consider just and proper to be disallowed. He can also be removed from his office by the tribunal. Talking about liquidator to make returns, etc. Section 353 provides that if any company liquidator who has made any default in filing, delivering or making any return, account or other document, or in giving any notice which he is by law required to file, deliver, make or give, fails to make good the default within 14 days after the service on him of a notice requiring him to do so, the registrar may make an order directing the company liquidator to make good the default within such time as may be specified in the order. Now we will discuss about meetings to ascertain wishes of creditors or contributories. This is dealt by section 354. It states that in all matters relating to the winding up of a company, the tribunal may have regard to the wishes of creditors or contributories of the company as proved to it by any sufficient evidence. If it thinks fit for the purpose of ascertaining those wishes, direct meetings of the creditors or contributories to be called, held and conducted in such manner as the tribunal may direct, and appoint a person to act as chairman of any such meeting and to report the result thereof to the tribunal. In ascertaining such wishes, regard is to be had to the value of each debt of the creditor and also to the number of votes casted by each contributory. Section 355 indicates the court, tribunal or any person before whom an affidavit can be sworn. Talking about the powers of tribunal to declare dissolution of company void. Section 356 of the Act provides that where any company has been dissolved, the tribunal may at any time within 2 years make an order declaring the dissolution to be void. Such order can be passed on the application of any person who appears to the tribunal to be interested or of the company liquidator. The person who applied for such order is under duty to file copy of the order with the registrar within 30 days or any time extended by the tribunal. The default under this respect is punishable. So, these were some of the provisions of the Companies Act 2013 dealing with the procedural aspects of winding up. Hope you have understood these concepts. Thank you for watching.